For pronouncement of judgment, item number 1.
In view of the above discussion, the writ petition stands disposed of. The original application filed by the respondent herein stands dismissed.
Adjournment requests, if any.
Then, yeah.
सर ये उन्होंने एक 23.8 में बोला था कि आपको रिप्रेजेंटेशन फाइल करना पड़ेगा पोर्टल इन्होंने वो कंडीशन वो दिया था
Your phone? What's the ground for adjournment?
No, withdraw का मतलब
Withdraw.
withdraw.
That's better. Wants to withdraw. Dismiss as withdraw.
What input?
Yeah. You argued it many a times. You argued it many a time. Twenty-third April. Eleven. He's in Eton again. In July. In July. June. 28th April. 28th. It's a hearing matter 29th probably. 29th. That temporary arrangement is going on. Going on.
Well,
What is on merit? You're absent from service since 2003. You have not joined the service.
No.
You are enjoying the private practice. What remains?
No, Lordship, only pair is only for today's accommodation, Lordship. I have consent taken from the opposite party also.
Day after tomorrow. Come day after tomorrow.
Okay. Next, can it be next week, Lordship?
Day after.
Or will I be?
You have asked for today the accommodation, we are granting.
Or will I be?
Hardly.
Yes, Your Lordship. I beg to mention item number 9, my lord. I'm praying for 2 weeks' time to file one affidavit, my lord.
What affidavit?
My lord, by order dated 25/2/2025, my lord directed me to obtain the
Regarding the
certified
FIR
copy.
and all.
Yes, my lord.
But the
Certified.
question is whether this security interest was created in favor of the bank or not. This is what the
Yes,
question.
yes.
On the basis of that agreement to sell and not. That is to be decided.
But they will be on the difference, they will be for this interest was already. It was already. Wasn't accurately. One minute later. I don't even care about the tribunal not visit, not agree. Okay.
22nd April.
Highly obliged, my lord.
May it please the Lordship? Item number 14. Can it be after vacation, Lordship? Do we have the consent of all the parties, my lord?
I mean, don't go anything. ठीक है सर
Arjan,
Obliged, my lord.
July.
Obliged, my lord.
Yes.
For orders, item 2.
May it please, my lord?
main
On the last date, my lord, it was my error. I wasn't there and my lord had to work. Grateful. My lord, this is an appeal by employees PF organization. The contesting respondent is the Airport Authority of India. What has happened is, between our disagreements, we have prejudiced respondent one's pension. And we couldn't explain or assist the learned single judge. The result was,
Explain and assist will come later on.
my lord,
What was your stand before the learned single?
my lord, the stand that was taken was that she would be either entitled to PF under EPF Act.
Come to internal page.
My lord,
Is that in 61? of the
61, my
written
lord. I am there, my lord.
Yes, second para.
Further, it is stated that why did the writ petitioner, Srimati Karuna Rani Roy, has prayed for disbursal of government pension of her deceased husband. The petitioner is basically aggrieved with the Airport Authority of India.
That's all.
This was our counter
Matter-
affidavit.
Matter comes and ends there. You have not objected for that before the learned single judge whether to grant her this government pension or not. Now you have come with a altogether new plea. There is no such provision in this with their organization to give such type of once it has opted for it, they can't opt for other thing. That's all.
May I answer this?
No such thing is there in the reply counter affidavit.
We
You have not controverted it.
my lord, we failed to correctly state what the
Not
law
only
was.
failed, sir. In fact, your clear stand was that it means you are agreed, okay, if the government is ready, they may grant it. We are not supposed to, we have nothing to do with. And
That-
when this lady is ready to deposit whatever the amount,
Yes.
what's the problem in that?
May I answer all this, my lord? Give me only a moment, my lord.
Yes,
Two streams of pension, one borne by the Consolidated Fund of India,
fine,
which is under CCS pension rules.
fine.
Airport Authority of India must decide her eligibility under that.
Yeah.
As a deceased employee's widow, that is her eligibility under CCS pension rule. Entire economic commitment under CCS pension rule is of the employer. Employee doesn't partake of any commitment.
Fine.
He is only a beneficiary. In marked distinction, EPF Act is entirely funded by employees' own contributions. Employer has no economic commitment there. Now, this gentleman contributed throughout and was entitled to the Provident Fund. He got that. AAI had no business and they did not object to it. Now, the entire confusion arose because since 1995, under the EPF Act, we pay part of the PF as pension. It's PF, but paid on a monthly basis, part of it. Since it carries that nomenclature pension, they took up CCS pension rules saying that dual pensions are not allowed. They completely lost sight of the fact it is employee's own money which is being paid to him.
Why have you not brought all these facts before the learned single judge? What's the wrong then in the order of the learned single judge?
One fact that we did bring before invite the attention of the learned single judge was we can't stop pension. One can't waive off their rights under the EPS, Employees Pension Scheme.
Where is that?
My lord, in our counter affidavit, we have said in as many words. Yeah.
Which paragraph?
May I? My lord, in fact, referred to my counter affidavit itself. May I just show where do we say that there's no provision for stoppage of pension?
There is only one page number 61 and another is page number 64, para 5 and nothing else in this effect.
64.5, my lord. May I just come to that? My lord, no, there is a statement which says that pensions under EPS cannot be stopped. I'll just show that.
Sure.
Yes. My lord, may only bear with me for a moment. I'll just show where that is. Would my lord please have page 58?
Yes.
The last paragraph. And the paragraph is not as properly worded should have been, but it says, may I place it, my lord? However, Vidal letter number such and such, dated 8th of July 2020, issued by additional CC, head office EPFO, it was instructed to the chairman Airport Authority of India that there is no provision in EPS 95 to transfer EPS accumulation of any pensioner to any fund, and monthly pension is paid as per entitlement under pension rule, the pension scheme. However, the list of employees who have been granted pension can be provided by AAI with PPO numbers, an amount of monthly member pension sanction. AAI may authorize monthly CAD pension after adjustment of the EPS pension. So the last sentence is the problematic one. It's in my counter and I disown it because it completely upends my act. And my lord, in all of this, I don't stand to lose anything. AAI doesn't. But this poor widow's human rights are completely gone for a toss, which is why it was incumbent upon us to come up in appeal, my lord.
How this poor widow's rights have been
because she's entitled to two social securities, one from her own money, as in her husband's money, other from the Consolidated Fund of India. They don't depend upon either. Under CCS pension, if her husband qualified for pension, he was entitled. Under EPF Act, he contributed his own investments. They are eventually paid off as PF.
if she wants to give up that.
My lord, that perhaps is not the reality. My lord may see the judgment and the tenor of the judgment throughout. One, AAI, and perhaps we are also complicit in that error. We gave her no option. It's a very unfortunate situation that two departments have presented her with a fait accompli.
That is her wisdom.
It's not her wisdom. Her petition was for her pension under CCS pension. She never ever said, I don't want my pension under EPS. In the course of proceedings, the government advocates present this situation before the learned single judge that only one can be given, which is completely incorrect, my lord.
What about the Madras High Court judgment?
My lord, we'll show, and I'll beseech my lord to take a different view. We would request my lord to see the act and see the CCS pension rules. They are completely distinct.
They have implemented. And that is beneficial. Look at the case. What is beneficial? This is higher than benefit. And इनको भी वो पैसा immediately देते हैं। इनको भी वो कुछ नहीं होता, लोग तो नहीं देते। Mr. Dubey, what is your problem? Are you claiming some money from the PPF account?
They will refund it. Sorry.
Mr. Praveen,
Yeah.
are you claiming the money from PPF so that you can, she's not been a contributor to GPF.
No.
So naturally, there was no deduction towards pension.
Yes,
So are you claiming an amount from them so
Yes,
that
sir.
that amount can be then utilized as pension?
yes,
Have you claimed that?
yes.
Where have you stated that?
But in the direction, only Honorable High Court has directed that this money should be adjusted. My lord.
No, what amount she has drawn,
My lord.
that will be adjusted. That's
My
different
lord,
thing. But the amount which is as a corpus with the PPF fund, are you claiming that amount also?
No.
No.
Now, may I clarify this?
Lord, your lordship would also see.
No, that's
Lordship would
perhaps,
pay-
that perhaps,
Mr. Counsel,
My lord.
we are
Page
having
58 for a
Idea.
moment, if your lordship sees, my lord.
Mr. Dubey, are you clear that you are not claiming the corpus fund which is there with PPF?
My lord, I may have to take instruction. My lord, one thing, my lord, I like to indicate to your lordship, if your lordships come at page 58. In fact, the affidavit which we had filed before the learned single judge, my lord, that is not on
Not there.
record.
It's not on record.
There is a memorandum, my lord. There are certain issues which are pending before the Ministry of Labor and Employment, my lord, which has not been adjudicated. And para 3 of page 58, if your lordship see. I can read, my lord. In the matter, it is submitted that Airport Authority of India and DGCA started processing the pension cases for issuance of government PPO while simultaneously requesting EPFO to stop the EPF pension. EPFO Regional Office Delhi, Central the Field Office, for ensuring compliance from Airport Authority of India, stopped PF pension in many such cases after due approval. So, my lord, there are around 400, my lord, what has happened because of, my lord, the change of the structure of the Airport Authority of India, my lord. My lord, there was a shift in the employees structure, my lord. And around 400 odd employees were entitled for government pensions, my lord, whose entitlement was under process, but they were getting EPF. My lord, a request was made pursuant to which initially EPF authorities stopped that pension and they were given regularized pension.
And very well.
Subsequently, my lord, they took a stand that, my lord, and the Act does not permit us to stop that pension, so we will not be doing that. And this matter was pending before the Labour Ministry, my lord. Therefore, if your lordship sees the order passed by the learned single judge, 3 or 4 times, my lord, direction was sought from the department, my lord, that clear the stand. My lord, then, my lord, in that same memorandum, this
Mr.
High
Dubey,
Court-
this Airport Authority of India, who is the pension paying authority?
my lord, it's the
It's your own authority.
no, my lord, it is not ours, my lord.
Then who is that authority to pay the pension?
So, Civil Department of Civil Aviation.
That means it is within the department only the amount PPO would be issued, not by AG or some other body.
No.
It will be issued.
regional RTO.
Regional Provident Civil Aviation Department.
Essentially, it's around verge of death. Eligibility for the If you- okay, okay. Because it's an issue of it, नहीं कर सकते तो यहाँ हमें कम probably immediately.
Yes.
Hello. If I may, Manoj.
Yes.
Look, in fact, if Airport Authority of India were to take an exception to our stand, there is a statutory provision for it. Under EPF Act, and I'm only summarizing my submissions, I'll show the provisions when my Lord so desires. Under EPF Act, Section 16 says, if an employee is otherwise covered under some statutory social security benefit, then either the appropriate government or the concerned department may make an application under the EPF Act, and that entire establishment would be out of the purview of the EPF Act. That wasn't ever done. And these employees continued contributing under the EPF Act. My Lord, may please have Section 16 of the EPF Act.
Yes.
Act not to apply to certain establishments. This act shall not apply. A is not material for us, my lord. It deals with cooperative societies. B, to any other establishment belonging to or under the control of the central government or a state government and whose employees are entitled to the benefit of contributory provident fund or old age pension in accordance with any scheme or rule framed by the central government or the state government governing such benefits. Now, my lord may see Central Civil Service CCS pension rules. Rule 2D thereof has a peri materia provision there. May I request my lord to please also have CCS pension rule?
1972.
Yes, my lord.
Which provision you are referring to?
Rule 2, sub-rule D, small d. May I place it, my lord? Application. Sorry.
Yes.
May I, my lord? Yes. Application. Save as otherwise provided in these rules shall apply to government servants appointed on or before 31st day of December 2003, including civilian government servants in the defense services appointed substantively to civil services and posts in connection with the affairs of the union which are borne on pensionable establishments but shall not apply to, and my lord may please have D, persons entitled to the benefit of a contributory provident fund. So whosoever is covered under EPF Act, by virtue of this, must walk out. Now the onus of doing application under 16 or under 2D lay on Airport Authority of India. This exercise was never undertaken. The consequence was these employees continued contributing to their provident fund under EPF Act. Once contributed, my lord, they have a vested right to that benefit because they have undertaken an economic commitment. Once this gentleman superannuates under the pension scheme, he becomes entitled to the pension. We start paying him.
Which is more beneficial for an employee?
My lord, in my respectful submission, that comparative analysis, of course, their pension as a standalone component, their pension is more. But that comparative analysis, that comparative analysis may not be material in this case because what we are paying is PF. They are paying pension. We are paying PF. All that we have done since 1995 is a fraction of the PF is also paid off as pension. Two distinct social securities. Now this person therefore becomes entitled to, my lord, in social security, what we do is we offer minimum core of social security. Our pension is a few thousand rupees. We pay that to ensure that people under a certain threshold nobody should go without medicine, food. So to meet that minimum economic requirement is what we pay as pension.
Sir, we are only concerned with the pensioner is, which scheme is more beneficial for the pensioner? This is what are, whatever the, if any rule
Yes, my lord.
which is detrimental to their benefits, we are not, that rule will not reject her or his claim, sir.
I am so grateful, my lord.
Yes.
My appeal is not about choosing between this or that. My appeal is she's entitled to both. It's not about my pension being
That is
paid.
what, let us agitate.
No, my lord,
Let her agitate.
my lord,
Let
the
her
tragedy of all of this is we made this poor lady come to the court and writ petition.
We don't understand why you people are so much agitating where a person is getting a scheme which is more beneficial. For that, and you are agitating for
Why we are agitating, my lord? Because this
what
is
what is the reason behind it?
yes,
The real cause.
the real causes, my lord.
Yes.
This problem is now multiplicating itself. There are
Yeah.
petitions in Delhi High Court, there are petitions in other high courts also, where different statutory bodies are saying we would meet our commitments under CCS pension only if EPS pension is withheld. Now, which is absolutely absurd. It is none of their business. It is not their money. Under
Contributory fund is only four days. How are we gonna maintain it? हमारी पेंशन और वहाँ पर भी उनको ये जो हमारी एम्प्लॉय वहाँ पे भी है कॉलेज आपने वो दूसरे में केस नहीं किया कॉलेज में जो people provincial वहाँ पे क्लियर कर रहे थे गवर्नमेंट शेयर ऑफ दिस केस अमाउंट को ओके तो उनको तो किसी दे भी सकते हैं किसको भी दे सकते हैं और तो नहीं कर सकते हाँ क्योंकि क्लियर नहीं कर पाएंगे एंड वंस वी कमेंट ऑन दिस वो डायरेक्टली इम्पोर्ट करता है Let's not depend on the planning subject to rule of the common share of the contribution is equal to the
Lord, one more submission on this, madam. Since my lords are, it's a very appropriate question. Perhaps an able advocate and a financially sufficient wherewithal person would have come up in appeal to defend their own rights. But one of the other flip side or the problematic consequences of this is it's settled now that the entire contribution under the EPF Act is from employees' pocket. They, in the concluding part of the single judge's order, say that money must go to them. That money never belonged to them. They are getting that money, which is employees' money to begin with. Now, there are multiple decisions, full bench of Madras High Court, Supreme Court, which say everything under the EPF Act comes from the employee's pocket. Employer has no business on objecting to it. Pursuant to those judgments, in fact, in other legislations also, when IBC was drafted, for instance, the question was when a company goes under insolvency or liquidation, its estate is drawn up for both the purposes. Legislature consciously said the entire bit of provident fund must be excluded because none of that money belongs to the employer. It is completely employees' money. So this aspect that EPF Act completely belongs to the employee's contribution now gets upended because of this choice forced upon this lady. Would my lord?
You are more worried about this, that you lose your, the fund, contributory fund which is lying with you. Not more than that.
My lord, we are custodians of this money. We are trustees of this money.
You have to, otherwise you have to transfer it. They'll also, otherwise how they will meet that pension requirement?
No, my lord, their pension is funded by Consolidated Fund of India.
Corpus fund. Both are government department.
No, my lord, sorry. We are maintaining corpus created by employees' money. They are withdrawing money from Consolidated Fund of India. TCS pension is funded by Consolidated Fund of India, not from employees' contribution. What the concluding part of the learned single judge's order says, you please transfer whatever the employee had contributed to Consolidated Fund of India. That can't be. Consolidated Fund of India is entirely borne by revenue expenses.
Ultimately, we have to take into consideration whatever the law and nothing else. Which scheme is more beneficial for the pension?
My lord, may I again invite my lord's attention? She must get both.
Let her agitate.
My lord,
Let her agitate.
we are faced with a situation, my lord, where these employees, these pensioners, these widows, these orphans, we are casting this duty for them to come up in appeal in all these matters which we are facing. Now, my lord, they may not have the wherewithal.
That is for you to deal with it.
My lord, may I only show the judgment? Because on principle, I believe, my lord, my stand is justified by the view taken by the legislature and the courts. There is no difficulty there. This equity balancing exercise which the learned single judge has done, that was not warranted in this. Her simple claim was grant me pension under the CCS pension. Somehow this issue props up that she is also drawing pension under EPF Act. That had no material basis in this. They completely besides the point here. My lord may only see the view taken by a full bench of Madras High Court. My lord, this is a judgment of the full bench of Madras High Court.
Yes. Dealing the same issue?
Dealing with the nature of contributions under EPF Act. No, once it's established, it's employees' money, then the transfer to AAI is unwarranted, my lord. My lord, may please see what the issue was. My lord, the issue was this. Paragraph 3. In the writ appeals, do my lords have that? Paragraph 3?
Yes.
Yes. In the writ appeals, the principal submission of the appellant, which is the employer, is that appellants are sick companies within the meaning of section 310 of SICA. And further, according to the appellants, 22(1) of SICA, when an inquiry under section 16 is pending before BIFER, then notwithstanding anything contained in the Companies Act 56 or any other law, no proceedings for execution, distress, or the like against any of the properties of the industrial company would lie or be proceeded with further except with the consent of the BIFER. It is further contended that since the EPF Act does not contain any non-obstante clause, and the SICA and the EPF Act both special statutes, and since the SICA came into force later than the EPF Act, in that case, the provisions of the SICA must prevail over the EPF Act. Reliance is placed on all these decisions, my lord. Now, my lord may see the reasoning. So the issue was whether we can assess under EPF Act when BIFER proceedings are on. Now, my lord may please have paragraph 15 of that judgment.
Yes.
In our opinion, the provisions of section 22(1) of the SICA has no application to the Provident Fund dues, and the provisions of the EPF Act would not come within the purview thereof. The Provident Fund and the dues payable under the EPF Act are part of the legitimate statutory settlements of the workers. Employer is obligated to pay the contribution of the employees as well as contributions to the fund, which is set up under the Act and the scheme framed thereunder. Employee's contribution, together with the employer's contribution, is required to be paid into the fund by the employer within the stipulated period. Now, my lord, these amounts, whether by way of contribution of the employee or the contribution of the employer, are monies which belong to the employee. Now, the second but the last sentence, my lord, the end of that paragraph, my lord. The last second sentence, the second last sentence, the money does not belong to the company, it belongs to the employees.
Yeah.
So this judgment, and this was followed by Supreme Court, my lord. We have that order as well. What the learned full bench says is that none of this money collected by EPFO can be laid claim to by the employer. He had no business regulating that money. These are really entrustments, my lord. Employee hands over 24% of his wages, asking the employer to deposit into the PF account.
Invest.
My lord, since the money belongs to the employee, he is entitled to get the benefit of it. What they have withheld is a distinct social security under CCS pension rules.
That is, let this pensioner come
The
before us
only-
to decide this.
The only hurdle against me is that I'm in appeal instead of the pensioner. Now, why at all I bothered, my lord, is because this is becoming a malaise throughout the country.
You're so benevolent. We are happy with that.
My lord.
But please, which scheme is more beneficial? This is a paramount consideration, and that's all.
Under EPF Act, these rights are non-waivable. Once contribution is made, one can't. My lord,
You are interested in saving your whatever this consolidated fund and nothing else.
well, I'm interested. Malo.
I don't.
No, I realized why it bothered us also, why the poor widow didn't appeal. We realized that. But by the proceedings before the learned single judge, it's quite apparent. During the course of the proceedings, Airports Authority of India says, we will only pay our pension if the other pension discontinues. That was their stand. This lady was, for whatever reason, lack of good advice, her own capacity to understand what's happening to her. My lord, we see the duress that has happened. Firstly, CCS pension.
Conduct some program in your organization and let the employees be aware. They don't go for this and stick to this. This is more beneficial than adopt for this.
Well, what has happened here is
Instead of arguing before the court that we are arguing on behalf of the pensioner.
no, I'm bound because my act has been completely distorted in this. The EPF Act, its understanding is quite crystal in this. Any social security beyond the EPF Act can be given.
Prevented you to take this stand before the learned single judge. The learned single judge would have taken a different view. Neither before the Madras High Court, neither before this court. And now suddenly you, this department became vice.
We did, my lord. We learned from our error.
That's very difficult for them.
We learned from our error, my lord. Today we are facing this difficulty elsewhere also. Perhaps there was some indecision on somebody's aspect. My lord, in fact, what is not part of this record is multiple communications were sent to Airport Authority of India that please desist from doing this. They are complaints.
This pensioner, she is at the verge of death.
So she's getting the
She is
pension, my
not
lord.
getting it.
She's getting the pension. Her rights don't
She
get
is
muddled up.
entitled- She is entitled for more pension.
My lord, my only request is this, she must get pension under Airports Authority of India. All we came up for that, let us also pay the pension she is due because it is from her own money. Now, Malad, this issue is also pending before National Human Rights
Take
Commission.
up this matter with the departments of the central government, they'll resolve it. Till then, we are not going to disturb this point.
Malad, her rights will be completely
Her
jeopardized.
rights, please don't bother for that. If our rights.
Malad, we are trustees. We are under the law.
You
We are
should
required to.
educate them that your rights are being compromised. If you are opting for this, you should educate.
Much unlearning has happened. To be very honest, my lord, the decisional error lies with both Airport Authority of India and EPFO. We should have done a better job in this. But which is why I am beseeching my lords to kindly intervene in this. This would sort out so many problems throughout the country, my lord.
We'll consider your.
I'm so grateful, my lord. I'm so grateful.
The matter comes upon for consideration of the yes.
Lord, if you lordship have a look at page 74 of
Are you aggrieved by the judgment of the legislature? Then sit down.
My lord.
This, the matter comes upon consideration of the IN number so and so with a prayer to condone the delay of so and so days in filing the connected rate appeal. So on last occasion, this court has made it clear that a connected rate appeal would be heard on merits along with the present IE. Stop. There is no serious opposition on the part of the respondents to the application for condonation of delay. Having heard the learned counsel for the applicant and after going through the contents of the application, we are of the view that delay of so and so days in filing the connected date appeal is liable to be condoned. Hence, IA is allowed. So and so delay in filing the connected date appeal is condoned. Full stop. Now, registry is directed to register the connected date appeal immediately, which is yet to be registered. Full stop. Next, with the consent of the parties, the matter is heard finally. Will dictate down.
I'm so grateful, my lord. I'm so grateful, my lord. I'm so grateful for the patient hearing.
Thank
Obliged.
Item number 4 for hearing.
Portion 1980, 1980.
Yes, sir.
My pleasure, Lord, my lord. My lord, in this case,
Yeah.
this app-
Your body language speaks much.
in this appeal, my lord, we have come appeal against the order passed by the learned single judge. Page 110.
Yes.
May I read, my lord?
Yes.
Heard Mr. D.K. Kotoki, learned counsel for the petitioner, also heard Mr. K.P. Pathak, learned counsel for the respondent 5, Mr. P. Nayak, learned counsel for the respondent number 6, Mr. T.C. Tutia, learned counsel for the respondent number 7, and Mr. N. Borua, learned counsel for the respondent number 9. The petitioner herein is aggrieved with the date of birth recorded in his service book, wherein it shows that the petitioner's date of birth is 1/3/1962. He is also aggrieved with the high school.
The learned single judge has rejected the claim of the appellant on 2 grounds. First, that he has approached the board in the year 1989 or 88 and his claim was rejected. Thereafter, he kept quiet. And just before 3 months, again, he moved an application for correction with the date of birth. That is a belated stay and therefore this court is not content.
Yes, sir. Yes, ma'am. Now, the petitioner, when joined in service,
Yeah,
at the time of joining in service, his date of birth was not correct because his date of birth, he did not even submit the HSLC certificate for entering in the record the date of birth. My lord, because he was claiming his date of birth to be corrected in the board. That it was not corrected, even though he has joined in service. That in course of time, if the date of birth is corrected, then it will be
when he joined the.
yes, my lord. He has joined in service on 7/7/1987.
7/7/1987.
87.
When he applied to the board.
Yes,
for,
board he has applied. Your lordship will find before that.
in
that-
which year he has applied for change of date of birth?
Yes.
I think
that-
he did not apply.
No, why not?
87, he joined the service.
He has joined in service and original date of birth has been submitted to the board for correction of the same through headmaster of the school and through inspector of school also it has been submitted. Then, my lord, since it did not work, so he has applied before the commissioner and secretary education department. Then your lordship will find that application, that representation was forwarded to the Board of Secondary Education, where your lordship will find Annexure 6.
Yes.
Yes, Annexure 6, your lordship will find page there's not Annexure 6. Yes, but Annexure 8. He has submitted representation to the commissioner and commissioner education department.
Inspector of the schools has forwarded it to the secondary, secretary board of secondary education.
Yes. Yes, mother. Annexure 8, page 41.
Yes.
Annexure 8, page 41. There your lordship will find. With reference to the subject, with reference to the above, I am to inform you that the application for correction of age of Sri Pradeep Gogoi who had appeared in HSC examination in 1979 cannot be considered now. As per rules, a candidate is to apply for correction of age within 3 years from the date of commencement of examination in which he or she appears. So it is not possible to correct the age of Sri Gogoi at this stage. He was already informed about this office data number so and so 22/12/88, a copy of which is enclosed herewith along with relevant rules of the board. In addition, he had noted the decision of the undersigned on 203/89. The original pass certificate was also sent in June 1983.
So have you challenged this order at any point of time?
It was because but the fact is little different, my lord. He was communicated with the original certificate in June 1983, whereas he has passed matriculate on 1979. In the 1979, so the rule which they are saying that within three years it should be corrected, that could not be done because already it is above 4 years. Above 4 years, because he was communicated with the original matriculate certificate.
Once the board has refused to change the date of birth in the certificate concern, what step you have taken against it?
He has gone on, my lord, submitting representation, my lord.
To whom?
To, my lord, even Commissioner of Education, again board,
No,
again.
How the Commissioner of
This way.
Education is not authorized to change the date of birth? It is
No,
only
yes,
the
yes, of
board.
course. Of course, my lord.
It is only the board.
Yes, only the board.
So against this board's action, what remedy you have availed?
Yes, my lord. Now Commissioner of Education, again, my lord, send the matter to the Secretary Board of Education to consider the matter as
Again.
a special case.
When?
That is, yes, that is, your lordship will find annexure 10, page 46.
Yes,
Annexure 10, page 46.
kind attention on the subject.
Yes.
I have honor to lay the following few lines in favor of your consideration. Sir, my age has been, this is your application, sir.
Yes, my lord. Now here,
This is
Commissioner
your
has also
application.
sent, my
Again,
lord.
you send an application. What happened thereafter? Thereafter, what happened?
What is that? He gave. Wait.
Mhm, okay, right.
Hmm. And basically, वो retirement के पहले स्टेट में 68 में हुआ था। मैंने निकल इसके बाद इन्होंने
Yes.
Yes, my lord. So, my lord, on the other hand, he was asked to submit the HSLC certificate for entry into the service book, my lord. Now he could not produce the original one. But that one, the one which was board has recorded service age as 17 years, that he has a xerox copy of it, he has submitted, and that has been recorded in the service book, my lord. But he has, that time, my lord, he has also informed to the authorities. He has also informed to the authorities that his date of birth may be corrected as and when, in any case, if the board rectified or corrected the date of birth. Your lordship, I will take your lordship to the, my lord, letter which I have submitted before the authority. Yes, my lord. Page 21, my lord. Page 21. The The letter I have quoted here, my lord, in the,
Yeah.
yes, to the Undersecretary of the Government of Assam, SAE Department, Dispute dated so and so, opening of service book. Respectfully, I have the honor to lay before you the following few lines for favor of your semi consideration. That, sir, I joined in Assam Secretary as a typist on 7/7/1987. Since then, my service book have not been opened, though it has passed about 2 years of my service in the Secretariat, as there occurs some dissimilarities of my age between HSLC admit card and the original birth certificate issued by the Board of Secondary Education Assam, for which I have been depriving of getting my increment benefit. In this connection, I submitted my aforesaid certificate in original to the Secretary Board of Secondary Education for correction of my age. But till today, I have not been favored with any good decision of the board. Here I have enclosed the photocopy of HLC admit card and original birth certificate for your perusal and needful. Under the circumstance, I therefore request you kindly to allow me to open my service book, providing me that if in future the age is corrected by the authority concerned, then age of my service book will be corrected accordingly. By informing this, he has given that the,
Simply said, if the date of birth is changed in that certificate, allow me to get my date of birth.
yes, my. Now,
Whether this board has ever changed your date of birth?
no.
Then-
Board did not change.
So you are
That's why
aware,
he has filed, that's
you are
why,
aware of this fact that the government is not supposed to change my date of birth and it is only the board.
board,
which
only the
change
board. Yes,
the
I
date of
agree,
birth.
my lord, I
And
agree.
that's why only.
No.
Now, if the board has not changed, how we ask the government that,
Yes,
despite that you.
Now,
allow-
before my retirement, the impeachment order has been passed.
Yes.
That is Annexure 19, page 68. Before my retirement, I have already informed that so and so my service may be corrected.
Corrected not, you said in case.
In
If it
case,
is
madam.
corrected by
Yes,
the
yes.
board, then I should also be
Yes.
allowed to get my date of birth
Yes,
corrected.
madam.
But the fact remains that the board has never changed.
Never change.
But
Never change. Now, the impeachment order has this part, passed in view of that, just in the vacant of my retirement, I have submitted. But it's not a fair. I have already informed that my date of entry into service is wrong. Date of birth, making
And in case, if it is date of birth is changed in the school certificate or HLC certificate, I may be
Yes.
allowed to
so,
change my date of birth.
yes,
That never happened.
never happened. And the impeachment order was passed that I have approached the authority.
So what's wrong in their action?
No, he is bored, my lord. He is bored.
Whatever the state
That
government.
the
who is-
state government there, they have passed the impeachment order that just before retirement, I have
and
informed them that
that is the law.
yes, I accept that. But I have already, since my joining, I have informed that my date of birth is wrong, my lord. Now, here simply said that,
Sir, since joining you has informed, and has also said that whenever my date of birth is corrected by the board, allow me to get the
yes.
date of birth
Now,
corrected.
my lord, if I come to the board now, in the year 1983, board has communicated me the original certificate.
Sir, 1989, when the board has rejected your application, what steps you have
Yes,
taken
against
that?
that, he did not approach
Then
before that.
nothing else, sir. Now you at the fag end of career, how can you compel the government that allow me to continue for 2 more years?
Now, well, something that the honorable single judge has arrived at the findings that I have approached before the authority before my retirement for a correction.
Material, sir. Ultimately, your letter itself says in case the board changes this date of birth, allow me to get it corrected, the same in the service book also. The board has never done that. Better ends here. That's all. Close for orders.
Item 5.
it is valuable to be all to be then we will record the memories. It is only latest together. That's video. That there are some you get about put among. Wait, with your lordship. It appears that grievance for which the petitioners have approached the honorable court, given it doesn't exist anymore, lordship, because of the development that has taken place. But I submit, lordship, that the petitioners' appellants are the recorded owners of the land in question, which they have inherited from their grandfather. During the grandfather's date, 1965, the respondent department did not have a land in that area. They request their grandfather to allow that land to be utilized for some times. They assure that you will be paying rent compensation, whatever in course of time.
Assurance.
Assurances.
Your
The fact-
grandfather is still alive?
No, lordship,
Your grandfather is still alive?
no, he died. It has come to us now.
Of your grandfather.
Now, if land has
Who
come to
knows,
us.
your grandfather may have given it on voluntarily, okay, use it, and whenever you are not in a requirement, give it the land. What's the problem?
No, lordship, that thereafter that it shows the record, the revenue department has now registered a land in now nine. By from inheritance, it has come to us now.
In the 1969, when this land was given by their grandfather, even, I think so, you are also not born.
Lordship. But now we have by inheritance, it is recorded in the revenue department.
So
We have
now,
become,
what is your grievance now?
now the grievances now, they have got their land now, government has allotted land, they are running the office independent. But even then the position is maintained by them, symbolic position by keeping a chowkidar. Now Chowkidar has given up the land, he informed us that we are asked to vacate the
You
land.
are in possession of the land.
I'm in the position of the land. I met the respondent number 7 also in the office. He said, no, it's your land now. We have given up. We do not require it
Fine.
anymore. The only thing is that I said, give me something in writing. He said, no, it was not taken on writing.
They have not taken the land in writing, and now you are in possession of the
Lordship.
land. Land is recorded in your name. What
Lordship.
remains?
And that's all. Nothing in that
That's
case.
all, then it's okay.
Nothing. Only except,
That's all?
I mean, what it was about pay, below. The submission of my journalist clearly that there was nothing. Page 36 of your note.
Yeah.
It's by a registered deed, number 6855.
Then why you have given up the land now?
Yes, that.
Why you have given up the land?
Not my lord, that is only his contention. But the fact that this land was given to the government by means of a registered deed, man.
Where is that registered deed?
Page 36 of your lordship brief.
Registered deed, where is the registered deed? By whom? By whom?
But, executed by him,
And where is the registered sale document? Please show us.
that fellow is
Remember
not
that this
there.
document has been submitted by the petitioner as Annexure 1, my lord. Annexure 1 submitted by the petitioner. Page 34. And we look at page number 6, my lord. The last column, it is written in last column, line 3. It is written,
Page number
page number 36, your.
36 is that Jamabandi or what?
Yes, it is.
No?
Yes, my lord. Yes, it is clearly written, registered deed number so and so, Jomunamuk Irrigation Office, my lord. Yes,
Is
ma'am.
that copy of that registered sale
It
deed?
is long, but it is written, made in 2000.
So, number is there. Show us the registered sale deed.
No, it is, I could not collect all, so it is strong pending case, my lord. On the other hand, the land is still in our possession, my lord. It is officers running there. It is filed, it's not filed in a wrong affidavit, my lord.
Now they have
It's
given up
not-
the position,
No,
released
my
in
lord,
our
petitioner
position.
has submitted wrong affidavit. I have collected some documents.
Simply want that recognition, this fact, that's all, nothing else.
No, my lord. This is a
Then
document.
let him deny my affidavit in that case, Lordship.
This is a document.
Let him deny my affidavit, which are filed now.
नहीं काउंटर नहीं उन्होंने काउंटर नहीं किया
কি document দিল আপনি?
আপনি কি এমনি সমস্ত হয়?
Have you filed the counter affidavit to the writ petition? Why? Why you are not filed the counter affidavit? Why you are not filed the counter affidavit?
Not-
But our court has
Now, who
given
is
them.
going to allow? Why you are not filed the counter affidavit? Now you are saying you have purchased it or purchased this land. Where is that purchase and all? Is this very much land? This registered sale is pertaining to where is this land?
Yes, Your Honor. It is a document. Yes, it's like, it is right. It is not actually the document, my lord.
Who has admitted it?
It is not, it's not admitted, it's mother, had an extra one.
Number 68, 69 again.
That's all.
Lordship, but to the latest Jamabandi 2017, Lordship, it shows that page 51, Lordship, page 50. It shows that land is recorded in our name. It has been mutated in our name, Lordship.
Okay, be happy with it.
And-
Be happy with it.
Lordship, Annexer 8, page 50. Now they have given position of the land to us. We are positioning the land. They are not replying our latest affidavit also. It is agitating on some papers, Lordship. Page 52 is the noting. Lordship, may kindly see page 52 of the latest Jamabandi. Right-hand side column. Type copy is there. At is five, concept in English, page 50, Lordship. Page 50, it's translated into English that land has been mutated in the name of these people. These are the petitioners here. The latest position.
Okay. This writ appeal. Despite. Appellants being agreed with the order dated
14/3/2023.
14/3/2024, 23 passed by the learned single judge in writ petition number 1864 of the 2022. Full stop. 22, whereby the learned single judge dismissed the writ petition filed on behalf of the appellant. The appellant has approached the writ court with a grievance that the respondent irrigation department is in illegal occupation of the land belonging to his family, which was owned by his grandfather, the description of which is given in the impugned order, since year 1965 and since year 1965 without paying any compensation to the family of the appellants. Full stop. The learned single judge, it is to be noticed that the respondents in the writ petition has not contested the claim of the appellants by filing any counter affidavit. However, the learned single judge has refused to interfere in the matter solely on the ground that if the land in question was acquired by if the land in question, only on the ground that the applicant has to, that the appellants have failed to place any material on record to suggest that the land was ever acquired by the department. And his claim for seeking compensation for the alleged acquisition of the land in the year 1965 is belated, and therefore no relief can be granted to the appellants while exercising the powers under Article 226 of the Constitution of India. Stop. During the pendency of the writ petition, the petitioners have filed an additional affidavit. The appellants have filed an additional affidavit in this writ appeal on 20th of February 2027, wherein it is stated that the respondent department has already vacated the possession of the land in question, and at present the land is in position of the appellants, the relevant paras of the additional affidavit or of the said additional affidavit are reproduced here under page number 68 there. Para number 6, Roman 6. Roman 6, then 7 and para 5. Okay. I have picked it. In view of the fact that as per the affidavit, additional affidavit filed on behalf of the appellants, when the department has already, when the respondent department has already vacated the land and the same is at present in possession of the appellants and their names have also been recorded in the revenue record and no counter affidavit is filed on behalf of the respondents, we are of the view that no further order is required to be passed in this writ appeal. The same is therefore disposed of.
Lots. Obliged, Lordship.
Give us the.
Item 68,
You are relying on this Goyal judgment.
Yes, my lord, Amarnath Goyal.
Amarnath Goyal.
And my lord, in view of the intricate permutation and combination involving in the manner, my lord, so as to giving a particular benefit to some, and some people are not getting it, some people are getting notional benefit. In order to ease out that, my lord, description, my lord, we have filed an affidavit, my lord, before this honorable court.
We'll
It-
go
it's
through
an-
it.
yes.
Yesterday we
Yes, but
we don't have any time
primary,
that going through those judgments.
yes, primarily we are relying as per following my lord, Amarnath Goyal. And Amarnath Goyal has taken into consideration past decisions passed by the
Nakara.
apex board. Yes,
DS
Tamil Nadu Electricity Board, yes, everything.
PK Menon, Nakara.
In fact, subject to what your lordship might finally decide, there is a fundamental difference between DS Nakara and Amarnath Goel. What the Honorable Supreme Court had observed, that when a new component is added, the state is within its right to demarcate when a new component is added. On the other hand, when an enhancement is done on an aspect which is already there, that is when the state cannot demarcate between two different classes. Has been, and in fact, all Manipur Association, Pensioners Association has differentiated both the cases. It has differentiated. Now, in this matter, subject to what your lordship will finally decide, the first point that will come for your lordship's determination is when the OM kicks into effect. If the OM kicks into effect from 1/4/2006, in any case, the respondents before this honorable court fall within that categorization. What the government has done is that the government has carried out a separate categorization. Even assuming Amarnath Goel stands, the state cannot rely on that to deprive me of my benefit, because I do not fall within prior to that 1/1/2006. That is my submission as of now. Yes.
That's right, but we need some homework.
Yes, yes, Your Lordship. Even Your Lordship had posed a query on the earlier occasion.
Yes.
But that is my initial basic submission, subject to what my senior friend would argue.
There is no liability.
Is this matter in the second week of June?
I'll be grateful.
I'm so obliged.
6, 7, 18.
Item 13.
May I please, Sir Lordship, I'm appearing for the sole respondent, Lordship. I would like to pray for a small accommodation today, Lordship.
Huh?
We have missed the item number today, so small accommodation, Lordship.
You have?
I for the sole respondent, Lordship.
Right Information Act.
So what?
Lordship will be adjourned
Right.
today, Lordship. We have missed the item today. Senior Counsel Bilidas is appearing, Lordship.
Is being made equivalent to it looks information information commission appointed as in terms of system equivalent to election with Hardly because so big because of the equivalent cannot be populated for
Yes, moving on.
Lordship, I would like to pray for an adjournment only for the day, Lord. Lordship, may I pray that my senior name may be reflected in the list, Lordship.
Yeah?
BD Das, Lordship. My senior name may be reflected in the list, Lordship. Mr. BD
Just
Das.
in the month of June, after showing name of Mr. B.D. Das.
My lord, same prayer I have also, my lord, my name also not reflected in the cause list, my lord, because of the.
Just in June 2025, but reflecting the name of Mr. Sharma for that, Mr. Sharma counsel for the petitioner as well as Mr. B.T. Raj and then senior counsel for the respondent.
Obliged. Obliged.
Item 15.
May I please,
Yes.
my lord. My lord, here the challenge is made to the order passed by the learned single judge. Now, the brief fact of the case is that, my lord, the respondent herein, my lord, joined in service in the year 1989. And my lord, on 8/4/2003, he submitted a resignation to the department, my lord, which was accepted by the department on 34, my lord, with effect from 34/2003, wide order dated 25/4/2003.
He submitted resignation.
On 8/4/2003, my lord. Thereafter, his resignation was considered by the authorities and approval was granted accepting the resignation, wide order dated, my lord, 25/4/2003, stating therein.
So learned single judge just said that before granting, before submitting the resignation, prior approval from the competent authority has not taken.
No, that is the first contention, my lord. Now, my lord, if I take my lords to the rules.
Yes.
Yes, sir. Yes, sir.
My lord, the relevant portion of the BSF Act and rules, my lord, I am placing. Oh, sir, oh. Yeah. Well, I am just, I have extracted the relevant portion. And first I would refer, my lord, to the section 8 of the BSF Act 1968.
Yeah.
My lord, section 8 states, my lord, that no member of the force shall be at liberty to resign his appointment during the term of his engagement or to withdraw himself from all or any of the duties of his appointment, except with the previous permission in writing of the prescribed authority. Now, my lord, it talks about permission in writing. It doesn't talk about, my lord, that prior to submitting resignation, there has to be a permission. It only says permission has to be granted. And that permission, my lord, was granted.
How do you elaborate it? How you elaborate?
My lord, it says, my lord,
Except no member of shall be at liberty to resign his appointment during the term of his engagement, to withdraw himself from any of the duties, except with the previous permission and writing to the prescribed authority.
it simply means, my lord, that the and member of the force, it does not have any right to resign. If he accepts the resignation, my lord, that resignation will be processed by the authority.
Single judge has said that prior to moving an application, there must be a previous approval, prior approval from the authority concerned, prescribed authority. So suppose if you say that I want to give my resignation, voluntary resignation, so and so, then the authority must allow you, okay, move your application. This is what.
No, my lord, no, my lord, that is not the interpretation. What is where the learned single judge is erred, my lord. This simply says, my lord, previous permission. Now, except with the previous permission writing, it does not say, my lord, that previous permission has to be before the submission of the
What the
resignation
learned
letter.
single judge result?
Because, my lord, it is only after the resignation, my lord, that the permission would be granted. My
So
lord,
if a
paragraph,
person submits a resignation, it doesn't mean that he's resigned until and unless the prescribed authority
grants
approves it.
permission, yes, and that can only be after the submission of the resignation.
What the learned single
Learned
judge?
single judge, my lord, page 122,
Para,
para 14, my lord.
read.
Lord, if I may read from para 12, my lord, because the individual starts from there, my lord. For the purpose of adjudicating the first issue, this court finds it relevant to produce. Para 12, my lord.
Para 12, yes.
My lord. For the purpose of adjudicating the first issue, this court finds it relevant to produce section 8 of the BSF Act 1968, which is quoted herein under resignation and withdrawal from the post. No member of the force shall be at liberty to resign his appointment during the term of his engagement or to withdraw himself from all or any of the duties of his appointment, except with the previous permission in writing of the prescribed authority. A reading of section 8A of the BSF Act 1968 would show that there has to be a previous permission in writing of the prescribed authority before a member of the force can be permitted to resign. The court finds it relevant at this stage to reproduce Rule 19 of the BSF Rule 1969 herein under resignation. The central government may, having regard to the special circumstances of any case, permit any officer of the force to resign from the force before the attainment of the age of retirement or before putting in such number of years of service as may be necessary under the rules to be eligible for retirement. Provided that while granting such permission, the central government may, these are the conditions which has to be considered, require the officer to refund the government such amount as would constitute cost of training given to that officer, or provided further that the officer of the force tendering resignation for accepting a job under central or state government or local bodies after having been granted cadre clearance for the same shall not be required to refund the sum as provided herein above. The central government may accept the resignation under sub rule 1 with effect from such date as it may consider expedient. The central government may refuse to permit an officer to resign if an emergency has been declared in the country either due to internal disturbance or external aggression, or if it considers to be expedient to do so in the interest of discipline of the force, or if the officer has specifically taken an undertaking to serve for a specified period and such period has not expired. The provisions of this rule shall apply to and in relation to subordinate officer and enrolled persons as they apply to and in relation to any other officer of the force, and the powers vested in the central government under sub rules 1 and 2 shall be exercised in case of subordinate officers by a deputy inspector general and in the case of an enrolled person by an commandant.
Yes.
So, my lord, under the BSF rules, my lord, there is no provision for withdrawal of resignation. That is governed by, my lord, Rule 26 of the CCS Pension Rules 1972. My lord, further coming to, my lord, the main my lord, analysis, my lord, so paragraph 14. A conjoint reading of sub rule 1 and rule 4 of rule 19 of the BSF rule 1969 with section 8 of the BSF Act 1968 and the same being applied to the facts involved herein, it would show that the commandant of the 128 battalion would have the authority to exercise the powers under 8A, section 8A of the BSF Act 1968, read with rule 19(1) of the BSF rules 1969, subject to a previous permission in writing, thereby permitting the petitioner to resign from his services during the term of his engagement. The provision to sub rule 1 of rule 19 stipulates that while granting permission by the prescribed authority, it has to be taken into account that if an officer have rendered less than 10 years of service, the central government may require the officer to refund such amount which constituted the cost of training given to that officer or 3 months pay and allowances, whichever is higher. However, the same shall not apply in respect of those officers who had accepted the job under the central or the state government or the local bodies after having granted cadre clearance for the same or who had completed 10 years of service with BSF. Sub-rule 2 of Rule 19 of the BSF Rule 1969 confers the discretion upon the Commandant 128 Battalion to accept the resignation under Sub-rule 1 of Rule 19 of the rules with effect the date as it may consider expedient. Sub-rule 2 of Rule 19 of the BSF Rule 1969 stipulates that the central government may refuse to permit an officer to resign. Therefore, combined reading of Section 8 of the BSF Act 1968 read with Rule 19 of the BSF Rule 69 shows that without previous permission in writing, an enrolled member like the petitioner cannot submit his resignation or such resignation, if so submitted, cannot be accepted. Now coming, now coming to the resignation, my lord, letter at page 25. Just to show, my lord, whether that prior permission was there or not. My lord, at page 25 is the translated version of the resignation letter, my lord, and at page 26, my lord, may turn the vernacular Hindi application for resignation, wherein my lord will see the different, my lord, notes by the officer concerned.
Read.
My lord. It is respectfully prayed that I, Constable
This vernacular language you don't.
Hindi, my lord, yes, resignation जाने हेतु सविनय नम निवेदन है कि मैं नंबर मतलब 890802 निर्मल कुमार कंपनी में की पर मैं प्रेरित हूँ। मेरी प्रार्थना इस प्रकार है कि मैं आपने घरेलू समस्याओं के कारण मैं सीमा सुरक्षा बल में अब और सर्विस करने में असमर्थ हूँ। मेरी अपनी सुरक्षा से नौकरी से रिजिग्नेशन जाना चाहता हूँ, अतः महोदय से विनती करता हूँ कि मेरा रिजिग्नेशन जल्द से जल्द स्वीकृत किया जाए, इसलिए मैं आपका सदैव आभारी रहूंगा। My lord, and my lord, on the left hand side, my lord will see the notes by the various authorities by which his application was forwarded for consideration. That, my lord, amounts to prior permission, and my lord will see put up for kind perusal. Then individual got a very genuine problems in his home.
Either you are arguing that yes, prior permission is required and therefore we have granted this prior permission, or you are saying there is no need for this prior permission for submitting an application. What is your argument?
But under the,
If you say that this is
No,
a prior permission,
my
this
lord,
is not
yes.
a prior permission.
the interpretation by the learned single judge, my lord, on Rule 8, that the prior permission has to be in that manner, that is, my lord, erroneous. In my humble submission, my lord, prior permission would simply mean a letter of resignation has been given. It has to be considered by the authorities, and it has to be followed by a formal order of accepting the resignation. Once that resignation is accepted, my lord, the consideration, the prior approval is deemed in that particular letter, and that is at page 27. Page 27.
Yes.
Page 27, my lord, says resignation tendered by Nirmal Kumar is hereby accepted. Now, this acceptance is followed by previous approvals, which has a notings on the application. And then, my lord, it says he be struck out from the stand with effect from. It's not that, my lord, the resignation letter was of 8/4/2003. The petitioner never withdrew this resignation. In fact, the civil suit which he has filed, saying that his resignation was my lord, forceful, that was also after 1.5 years. So therefore, my lord, in the admitted facts and circumstances of the case, there is no withdrawal of resignation by the petitioner. and it is an afterthought.
That is, the learned single judge simply said acceptance of resignation is bad because prior permission was not granted to him to submit an application for resignation. This is what the single judge said. Withdrawal and nothing, no withdrawal. There is no question of withdrawal.
That is also another question of law, my lord, that whether when the resignation has not been withdrawn and it is accepted, the
Yes, Mr.
employer.
Majumdar.
And
One sentence from the appeal itself, what they were trying to say. The fact that the acceptance of resignation was not as per provisions of Rule 19 of the BSF Rules 1969 will not convert the resignation to a case of voluntary retirement. That is one of the grounds taken.
that is the second.
So it is
We'll
the
come to-
fact that it has not been done as per provisions of Rule 19 is an admitted position. Now, when the resignation goes,
Yes, yeah, what is the interpretation of it, Rule 8 and Rule, this Section 8 and Rule 19?
is that actually has been discussed by the learned single judge at page 123 on what was argued. Under such circumstances, this court put a query at page 123.
Yeah.
Under such circumstances,
Yeah, that is there.
we put a
That is
query
there.
and
Ah.
that was the result that was got, that there was no prior permission granted.
So you mean to say that suppose an employee tomorrow
Yes.
wants to resign,
Yes,
then he'll move an application
yes,
to the authority.
yes,
Okay, I want to resign.
resign.
So please allow me
Hmm.
to furnish an application seeking voluntary retirement or withdrawal from service.
Service, yes.
Then he'll say, okay, we grant you the permission. Then he will move an application, okay.
Now I may be permitted to resign from.
So मैं
True.
परेशान हूँ फैमिली की और मेरे को रिजाइन दिया जाए ये
Unless,
interpretation.
unless that is the procedure, what happens is a person faces a disciplinary proceeding or a person has got less than 10 years of service where he is required to refund. He first says that I want to resign. I have circumstances to resign. It will then be upon the commandant to say, okay, you don't have 10 years of service unless you refund the money. I cannot permit you to submit an application for resignation one.
That he can, when he
Or-
can say when a person moves an application, they can refuse to accept it. But in case where application is moved
Yes,
and that is to be accepted, then the prescribed authority has to give his permission. Okay, he has moved this application. He may be allowed to withdraw or resign from the service, and therefore I am granting the approval for them, for the same. It doesn't mean.
then, my lord, if he has to refund the money, the acceptance will become conditional acceptance. Resignation can neither be given conditionally nor be accepted conditionally.
That the rule permits.
The rule cannot do it because my lord, resignation can never be a conditional circumstance. So therefore, initially, unless and until there is a permission that yes, you are in a state where you can give a resignation. That permission comes, I may decide to resign or not to resign. That stage will be there, my lord. And what the learned single judge has given is not the reinstatement in service or any other benefit,
Oh, okay. That's another thing. The relief part is altogether different.
my lord. Otherwise, my lord, the reading of the rules, as I read it, my lord, he first has to be in a position to submit a letter for resignation. He has to be qualified enough to submit a resignation. Otherwise, it fails. That is what. Okay.
One judgment to rely.
With judgment.
My lord, the second part, my lord, after the first deciding the first issue, my lord, that resignation is not as per the rule. Second,
In fact,
the second relief, my lord,
is to
to treat it as a voluntary, retirement. My lord, resignation cannot be, resignation and voluntary
The
retirement.
voluntary retirement part has
Both
been
are
brought in because there was a
completely
submission in
different.
the court saying that I may not be a fit person to now return after 20 years. Something had to be done for the period.
Resignation cannot be deemed to be a voluntary retirement. Because, my lord, under there is a judgment, my lord, because above 20 years service is minimum required for pension in BSF. There is a Supreme Court judgment, my lord. So you will not be entitled to pension.
That part would come in. If I'm allowed the continuance of service, the notional period is there. In case lordship holds that the resignation acceptance was wrong.
Please do some research. There is a recent judgment of this court, division bench,
Madam.
interpreting these similar rules in Assam, right? But the Karnataka has taken, where the division bench has taken a different view of these rules.
Assam reference.
You are also playing on.
एक और बस बात।
Read both of you. Twenty-three paras.
Exactly.
Mother judgment will be. What is it?
Ablation.